Hey everybody, Mark Dawes here. I hope you're all doing well during lockdown. I thought I'd just knock out another video while I'm here. And I thought I'd do it around this post that I put out on LinkedIn and also put it out on Facebook and other platforms as well. And the heading of this post was, an unfair dismissal case found that you can't be sacked for using reasonable force to defend yourself and others at work, even if your organisation has a no-touch policy. Now, this post attracted a lot of interest. 6,522 views of the post. We had 22 comments on this post, so it obviously attracted a lot of interest. But in this case, and it's a moot point that I want to come to, is you can't prevent someone from enforcing their rights at work when it comes to self-defense. I've had this with schools where children have been bullied, the child's reached the point where it can't cope anymore, eventually turns around to the bullies and defends themselves against the bullies, and then the school says, oh, we have a no fighting policy or a no touch policy. The child could be excluded. We've had to deal with that as well, and I'm happy to say in virtually every case where we've dealt with it, there's been no action taken against the child, and the child hasn't been excluded from school. So the question is, how far should organisations go in training their staff with regards to the use of force? Because I can understand where the organisation's coming from. On the one hand, they want to keep their staff safe. On the other hand, they don't want their staff going rogue and going absolutely mad and using mad amounts of force, if you like. But here's another case before I answer that question. This was in the Safety and Health Practitioner on the 19th of October 2020. A counsel was fined after a teacher was assaulted by a pupil. Now, the Health and Safety Executive investigated this council, which was Luton Borough Council. They found failings and they prosecuted them under Section 2 of the Health and Safety Work Act. And in this case, the council was fined £104,000 with £60,000 in costs. But this is what the HSE said. They said the HSE's investigation found that there were significant shortcomings in relation to the measures at the school regarding violence and aggression posed by the pupils to others. No effective consideration was given to the risk of injury or death posed by the pupils to others, and measures were not taken to reduce the threat to as low as reasonably practicable. So, again, no measures were taken, no risk assessments probably done, and no training, or if training was given, it wasn't given to the required standard. Now, a lot of organisations out there are risk averse when it comes to training staff, and I get it. You don't want your staff using mad amounts of force to hurt people. But by the same definition, if you limit their rights, and I hear this a lot, that staff can use, for example, the minimum amount of force. Minimum, as you know, because I've spoke about it myself many times, is not a legal standard. The standard in this country is reasonable force. And then if you want to look at public authorities and public officials, you've got the Human Rights Act, which talks about absolutely necessary force, and that's a different issue again. So, for example, let's talk about the SIA. People say, oh, the physical intervention training for door supervisors is rubbish. It doesn't go far enough. Well, this is our webpage, and I clarify all this stuff. So I go and ask the questions. And on here, if you want to go to it, it's you can find it on our website. But if I scroll down to here, you'll see here it says, what is the scope of the SIA Level 3 Physical Intervention Award? And this was what the SIA responded to me when I asked them. They said, as a general comment, the purpose of the SIA training is to establish the standard required for someone to qualify for a license. We don't restrict training. We encourage employers and individuals to get any further appropriate training where it is necessary for their specific needs. So what the SIA is saying, in their defence, is we're going to give some training because it's better to establish a baseline standard with some degree of skill than not. But if people at work, door supervisors in this case, are going to experience high levels of violence and aggression where they're going to need more restrictive techniques or more effective defensive techniques, then you, employer, are legally bound to give them that under health and safety legislation, as this case found here when the school was prosecuted. So going back to this post here, I just want to summarise this because Lord Justice Mumby many years ago made a ruling, and he said basically that you can't put up a wall and stop the law from coming in. Now, many trainers and consultants watching this, because there's a load of you guys and girls out there who are hugely experienced, you'll get this. Someone will say to you, I'd like some training for my staff, keep them safe, or they have to restrain vulnerable people, keep them safe. But I don't want any training that's going to likely injure the people they're restraining because I don't want to be liable for it. Well, the fact is you're liable anyway, so let's just put a line under that one. Whatever training you as a commissioning agency choose to take in, you're liable for it. Whatever training provider you choose to engage to deliver that training, you're liable for, not the training provider. So I'd be very mindful about certain standards or certain guidance or certain rules that are made up by certain individuals that say you can only use the minimum amount of force. You're only allowed to use these techniques. You're only allowed to go this far. Because the law is absolutely clear, as was proved in this case. The law allows each and every citizen of the United Kingdom to use force as is reasonable in the circumstances, and that is the baseline standard. Okay? It doesn't say reasonable to this level. It's reasonable in the circumstances. Minimum force is another thing I've spoken a lot about. It bugs me because people say, well, you can use the minimum amount of force. There's no legal standard for minimum, so that leaves that open to discussion and probably puts a standard in someone's head that they can only use less than reasonable. This is why when we train people, we provide a manual of guidance and we go through a load of techniques which are all risk assessed, they're all medically reviewed, they're all fit for purpose, but we make a statement in our manual that it does not prevent a member of staff from using force that is reasonable in the circumstances as they believe them to be if they are, if something falls outside the scope of the training that they've been given, because you can't account for everything. Now, years ago, I spoke to a professor of law, who's sadly now deceased, a brilliant man, and he said, the reason there is no encyclopedia of techniques for every situation you'd come across, for every type of eventuality, is it would never end. It would probably go around the world and back, because you can't account for every physical technique. You can only apply force that's reasonable in the circumstances. So that's the point of this short video, and here's the offer for you. If you want a course, because I'm sat at home at the moment and don't think I've got nothing to do, I'm busier than I've ever been, but I'm willing to do a webinar on reasonable force, on understanding reasonable force. It's been my passion for 30 years. That if I was in Mastermind, that would be my expert subject, if you like, my specialist subject. I'll put the webinar on, and if you want to come along and do the webinar, that's great. I'll even give you a CPD certificate if you want it, to give you some CPD so you can evidence that you've actually had some training on reasonable force, or more training, or you've refreshed your training, whatever it is you want to do. But that's the offer for you, because like I said, a lot of people were interested in this post, and we had a lot of hits on Facebook too, and a lot of people visited the blog site. So that's all I wanted to say. If you're interested, just stick a yes in the comments box below where you see this video, and if we get enough yeses, I'll stick the webinar on. All right, have a good day. Speak to you soon.